Dan did that video recently about statutes and what was the oldest statute. So what I thought I'd do is I'd just share actually the oldest statute that I can remember recently using in a case. But what's perhaps interesting about this is it might be of actual practical use to a lot of people watching. So which statute am I talking about? I am talking about the Statute of Frauds 1677, which uses lovely flowery language. No action shall be brought whereby to charge the defendant upon any special promise to answer, spelt weirdly, for the debt, default, or miscarriages of another person. And it goes on to sort of other things. This is the statute, actually, that means that all property deals have to be recorded in writing. I mean, normally contracts can be, oral. They don't need to be in writing, but land contracts do, except, of course, when they don't. You get into all sorts of things to do with equity there. But why this is useful, it's probably easy just to tell you what the case was. Okay, somebody was director of a company, and he was being chased for some bills from a company that provided services to the company. And they said, well, there's personal guarantees against all directors. The company hasn't paid it. We can chase after you. And his argument was, well, hang on a second. This was all signed, done before I was even a director of this company. And the guy who actually signed that contract is no longer a director. But it's very common, this. Say, for instance, you're in the building trade and you just go down your builders, merchants, and you get a trade account. If you read the small print, you'll probably see there's what we call a personal guarantee there. Because, of course, the whole benefit of buying things as a limited company is limited liability. If it all goes horribly wrong, then it's the company that's chased for the debts, not you personally. You have this corporate veil. But lenders and people who offer credit can get around that by saying, I want a personal guarantee. But what this law says, you can only be responsible for a personal guarantee if you personally have signed it. And in this particular case, there's a clause saying that anybody signing this agrees to provide a personal guarantee, and all the directors of the company will provide personal guarantees. Now, generally speaking, one person, like director of a company, can bind the company and the other directors in terms of their directors' duties. But what this law says is you can't actually bind somebody in a personal capacity. So whoever actually signed, for the trade, the trade account, or who instructed a company to provide services, accountancy services or whatever, they might be personally liable because they have physically signed it, but they can't bind any of the other directors. There is an exception, which is unless there is authority. So say, for instance, you'd given power of attorney to somebody, then yes, they arguably could bind on your own behalf. But yeah, I mean, like I say, it's an old law, but it's one that's still very much enforced, possibly because it makes so much sense in that where people are going to be liable for huge amounts of debt, then it might be nice if there's a record of that somewhere. So there you go. As always, hope you found that vaguely interesting and possibly even vaguely useful this time, especially if you are somebody who signs up to trade accounts, or somebody else from your company, your co-director's gone down and signed something. You might think he's just sort of signed your life away, but he probably hasn't.